Welcome to the Distressed Business Playbook.
Welcome to the Distressed Business Playbook with attorney Todd Duffy, founder of Todd E. Duffy PLLC. Todd is a New York bankruptcy attorney who works with businesses and decision makers navigating financial pressure, restructuring, and complex legal challenges. I'm Evan Mack, and today we're talking about how the automatic stay works and what it actually does once a bankruptcy case is filed. How you doing, Todd?
I'm great, thanks. How you doing, Evan?
I'm well. Good to see you. So, Todd, can you explain what the automatic stay is and what it's meant to do once a bankruptcy case is filed?
Sure. So usually when debtors come to me, they are in chaos. They've got a lawsuit. They have people chasing them for money, and they are looking just to get a breath, try and figure out how it is that they can get their business together and their finances together so they can start paying their creditors and figure out a way to pay everybody so they can keep their businesses going. The automatic stay is the solution. What happens is you file what's known as a bankruptcy petition. And the moment you file that bankruptcy petition, there is a stay put in place automatically, hence the name automatic stay. And the stay literally stops everything. There's a specific notice that I can send out, but it's generated by the court automatically. There's no court appearances. No judge has to enter an order first. I don't have to wait to get a date for a hearing. It's just filing the bankruptcy petition, and boom, everything's stayed by law.
What actually stops the moment automatic stay goes into effect? What tends to surprise business owners about that?
I think that everything stops, quite frankly. Every type of collection activity stops. And I think business owners in general are so used to having to deal with those kinds of financial conditions that they are surprised by the relief that they feel the moment that they've actually gotten the stay in place.
Where does the automatic stay not go as far as business owners expect?
Well, let's say, for example, this is not your first filing or rodeo, and you go ahead and you file anyway, what bankruptcy lawyers would call, instead of a Chapter 11, a Chapter 22, and you're behind on your rent. In certain cases, not in every case, but in certain cases, if you're a serial filer, the landlord could come into court right away and say, listen, he's behind on his rent. I want automatic stay to evict him. So there is a motion that any creditor can make called a motion for relief from the automatic stay, which asks the court permission under certain complicated scenarios where they can go forward and either enforce a judgment or get a judgment or do, whatever they feel they need to do in order to secure their claim. In most cases, number one, you can stipulate those things so it doesn't take as much time. But the most important thing you can do with that is you can make sure that the only thing that they're going to do is to chase a judgment, but not try and go and collect on that judgment. And so that even if they went and got a judgment, they couldn't collect it. They still have to come back to the court for distribution.
How do creditors typically react once the automatic stay is triggered, especially in business cases, Todd?
I haven't seen many creditors that are happy about it. I think that on the creditor side, most people have felt frustration. The drama between the creditor and the debtor could have been going on for years before the debtor decided to finally file. I found that a lot of debtor clients don't want to file, so they take forever to come to the conclusion that they need to file. And when they do, there's a lot of animosity built up between creditors. Once they learn they're not the only creditor, ironically, then it sometimes makes things a lot easier to deal with. And bankruptcy lawyers are trained to make deals. So, what we do is we go in and meet with, talk with these creditors. Hopefully we can get a reduction in their claim, or at least some agreement that they're willing to abide by so that their claim can get paid through a plan of reorganization.
What does it look like when a creditor pushes up against that automatic stay, and how is that situation handled?
Well, I guess when you say push up against, I'm wondering if you mean with it or without court permission. So, there's kind of almost like two flavors, right? So the first flavor would be a scenario where a creditor learns about the automatic stay and says, you know what, I don't care, and keeps doing what they're doing. That is depending on the type of case you have, that is contempt. Why? Because there's a court order in place that says there's an automatic stay. So the court order is automatically generated, and the moment that a creditor violates that automatic stay, is liable for sanctions, contempt sanctions. And if a court orders the person into court and sanctions them monetarily, civil penalties, those penalties would only escalate especially if he ignores the court, because then it's a whole jurisdictional issue. And, judges are not really keen on people ignoring their orders generally.
What changes for lawsuits that are, already in motion when the automatic stay kicks in?
Everything comes to a standstill. So I have been in New York State Court with clients that had just filed, mostly because I wanted to inform the judge. I'm not a state court practitioner, but when creditors hear about the automatic stay, or when I appear in a state court and I explain that this is stayed, basically the judge will shut it down immediately. And there are two things that could happen, I guess. The judge could say, that's fine, I'm going to shut this down immediately, and we will wait until a judge on the federal side will enter an order lifting the automatic stay, allowing the case to go forward. Or that may be fine, but there may be other defendants, notwithstanding the automatic stay, who haven't filed for bankruptcy. So they may continue as to those other defendants. But generally speaking, state court judges are wary of violating federal law, and they'll just suspend the lawsuit altogether.
Can you walk us through a situation, Todd, where the automatic stay made a meaningful difference for a business under pressure?
Sure. I represented a construction company a long time ago. And the construction company was in the midst of a million different litigations from his landlord and a number of creditors. And the relationships with his suppliers were breaking down, and he had a number of liens on properties that he had been working on. And because he was able to file a bankruptcy, he was able to continue in his business, continue to earn money, and continue to find a way to pay his creditors over the course of a 5-year plan. And the business was able to continue that way.
What problems can still continue or even get worse, even with that automatic stay in place, Todd?
Well, the most important thing, I guess there's two things that I think are tied for the most important thing. The first is you got to pay your taxes, because no federal judge is going to want to hear that you're in bankruptcy, but you're not paying your taxes.
Yep.
That's the first and most important thing. And it's the first question I always ask. Are you up to date on your taxes? Have all your taxes been filed? I think the second thing that's the most important thing is how well you're working with that creditor to get these deals done and to be able to make things happen. But you have to pay your creditors that are secured. By secured, I mean, for example, let's say the business owns a building and there's a mortgage on the building. You have to pay those things even after you file. You may not have to pay the arrears, but you have to pay current. And so once you pay current, if you stop paying current, then that's an easy way to get yourself outside the automatic stay. And the judge will immediately lift the automatic stay and let them, foreclose on the property.
So, Todd, where does the automatic stay become a strategic advantage in restructuring for people?
Well, so when you're a creditor and you're in the process of fighting all of these battles on multiple different fronts from creditors that are merciless, the automatic stay gives you one, peace of mind and time to take a breath and figure out how you're going to restructure. The second thing that it gives you is what bankruptcy lawyers will call leverage. You are able to negotiate, because when creditors think that they have everything in their favor, they're not going to negotiate. But when you have the automatic stay and you're in bankruptcy court, then they know they have to negotiate, or else the judge is going to be pretty upset and they can't move forward.
Good stuff, Todd. Appreciate the time, sir.
Thanks, sir. Appreciate your time.
All right. That's it for today's episode of the Distressed Business Playbook. If you'd like to learn more about Todd Duffy and his work with businesses navigating financial pressure and restructuring, visit teduffylaw.com. Thanks for listening, and don't forget to like, subscribe to the show, and share this episode with someone who might need it. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.